すいません、申し訳ないです。
Good morning. Welcome to a press conference at the Foreign Correspondents Club of Japan. My name is Teddy Jimbo. I am I'm a co-chair of the committee that organizes all the media events at this club, and I'm a moderator today. And we have 頭のところは通訳は大丈夫です。はいはい。And we have a very special speakers today. To me, they are also very special speakers because this is a very important issue that has to do with the so-called eugenics policy. Many of you might think that eugenics is a thing of the past, often associated with the Nazis, and many might think, it has cherished from the surface of the earth. But believe it or not, in Japan, we had the so-called Eugenics Protection Act up until 1996. And government has only acknowledged its wrongdoing 4 years ago, 2019. And now we have a series of lawsuits by the victims of this, the application of this law, because this law forcibly conducted sterilization procedures to those who are mentally ill or who had some handicaps. Because for the name of terminating the bad gene, of course, that's what the eugenics is all about. And many lawsuits are filed across the country. And people, by the way, about 25,000 victims had received a forceful sterilization, and most of whom were not informed about it beforehand. And even afterwards, many of them were not aware of what was done to them. Many lawsuits to demand compensation from the government for that. By the way, this actual procedure often included removal of testicles, and also some actually involved tying the fallopian tubes, and also uteruses, removal of uteruses, also forcible abortion. Many forcible abortion took place too. 75% of those victims, 25,000 victims, were women. So anyway, the lawsuits are going on, and believe it or not, while court acknowledges the wrongdoing of the government, many courts have refused to award a compensation, saying that statute of limitation has expired. There's a 20-year statute of limitations, and the thing is, many victims were not aware that they were actually the victims up until very recently, because information was not disclosed. And as I told you, law was intact up until 1996. So it was actually perfectly legal up until 1996, believe it or not. Anyway, we have three speakers today. And first person I have to introduce is Junko, Iizuka Junko-san. It's actually alias, the pseudonym, not the real name. But she's 77 years old, and she has received the tying of the fallopian tubes at the age of 16, of course, without her knowledge, without her consent. And she's actually the plaintiff of a lawsuit demanding a compensation in Sendai area. And lawyers will explain just recent development on the lawsuit, and that's one of the big focal point in this press conference. But anyway, she's a plaintiff. She's at the age of 77, and she's of course my furthest right to your left. And we have a lawyer, Koji Niisato. He actually he chairs the victims of this law, the plaintiff group. So he's the head of the plaintiffs group in this series of lawsuit. And my immediate right is Yasuyuki Tokuda. He's also head of the lawsuit taking place in Oita. So we have two lawyers who represent the victims and the victim herself with us. And each will speak briefly, and then I'm sure you have many questions you'd like to ask. So we will like to secure as much time as possible for Q&A. And interpreter today is Yuki Takayama Yuki-san. And she will interpret Japanese into English as well as English to questions into Japanese. Okay, so we will start with the Niisato senseiからよろしいですね。はい。Okay, we'll start with the lawyer Niisato, and then move on. じゃあよろしくお願いします。
はい、本日はこのような機会をいただきましてありがとうございます。旧優生保護法国賠訴訟の現状と早期の政治解決を求めてという話をさせていただきます。私自身は全国優生保護法被害弁護団の共同代表の新里浩二です。
Thank you very much for this very important opportunity to speak about the current status of the state compensation lawsuit regarding the former eugenics protection law and seeking early political resolution. I am the co-representative of the lawyers group for Japan Eugenics Protection Law Victims.
はい、まず第一に旧優生保護法の成立と改正でございます。旧優生保護法は戦後新憲法が施行された後の1948年国会で全会一致で成立しております。戦後の人口急増に対する人口政策が主な目的とされておりました。
I would like to first talk about the enactment and revision of the former eugenics protection law. The former eugenics protection law was enacted unanimously in the Diet in 1948 after the post-war new constitution was put into effect. The main objective was to implement a population policy to deal with the rapid increase in population after the war.
法の第一条の目的に、優生上の見地から不良な子孫の出生を防止すると明記されて、特定の障害や疾患を有する者を一方的に不良なものとして、不妊手術、中絶手術を強制する法律でございました。
Article 1 stated the purpose is to prevent the birth of bad offspring from the standpoint of eugenics. It was a law that unilaterally defined persons with specific disabilities and conditions as defective or bad and forced them to undergo sterilization and abortion operations.
法律そのものが不良と人間のを選別している点で、ナチの男子法よりひどい法律だと、東京大学の市野川教授とはおっしゃっております。有形力の行使、ベッドに縛り付け、麻酔薬を打つや偽毛行為、他の手術と偽るなども許されておりまして、法で認められていない子宮摘出手術などが行われるなど、ずさんな運用も多く見られました。
According to Professor Ichinokawa, professor at the University of Tokyo, the law was worse than Nazi sterilization law in the sense that it categorizes the people as defective or bad. The operations were not properly managed either. The use of physical force, such as tying to bed and injected with anesthesia, and use of deception disguised as other operations were permitted. And although not permitted under the law, operations such as hysterectomics were performed as well, which is hysterectomics, removing of the uteruses.
1996年、優生手術に関する条項を削除し、母体保護に改正されました。1994年のカイロ国際人口会議で、優生手術が問題にされたため、国が障害差別に当たるとして、急遽法改正を実行したものでございます。国民には法律や優生手術の問題性は知らせられておりませんでした。
In 1996, the law was amended and renamed to the Maternal Health Act, removing the provisions on eugenic surgery. Eugenic surgery was raised as an issue at the Cairo International Conference on Population and Development in 1994, and the Japanese government hurriedly revised the law, recognizing it as a discrimination against persons with disabilities. However, the Japanese citizens were not informed of the law or the problems of the eugenic surgery.
法律の改正後も国は当時は合法だと表明し続けて、そして救済・保障を全く放置してきました。
Even after the amendment of the law, the state continued to declare that it was legal at the time and neglected to implement any relief measures.
2番目として、優生手術の種類と被害実態についてお話しします。優生手術の種類でございますけれども、大きく分けると、優生保護審査会の審査を要件として、本人の同意なく行われるものと、本人及び配偶者の同意がある場合に行われるものの2種類でございました。
So next, I'd like to go over the types of eugenic surgeries and actual damage caused by such surgery. Broadly speaking, there are two types of surgeries conducted. There are those that require a review by the Eugenics Protection Panel, which can be performed without the consent of the individual, and those that can be performed when the individual and his or her spouse consent to the surgery.
被害者数や被害実態でございますけれども、本人の同意がなく行われた優生手術は16,475件、本人の同意による優生手術は8,516件、しかし、真意の同意とは見なされるものではございませんでした。合計24,991件でございます。
As to the number of victims and actual damage, a total of 24,991 eugenic surgeries were performed, of which 16,475 were without the individual's consent, and 8,516 were with the individual's consent. However, the consent cannot be said to be voluntary.
では、どのような人権が侵害されたかということでございます。弁護団は、本件は違憲な法律に基づく国策として行われた人権侵害であり、戦後最大の人権侵害であると位置づけております。
What human rights were violated? The attorney's team considered this case to be a violation of human rights carried out as a national policy based on an unconstitutional law, and the most serious violation of human rights in the post-war era.
判決の中では、立法目的自体が極めて非人道的で、個人の尊重を基本原理とする日本国憲法の理念に反すると述べています。
Some courts have said that the legislative purpose itself is extremely inhumane and goes against the principle of Constitution of Japan, which is based on respect for the individual.
さらに、個人の尊重を定める憲法13条違反、13条に基づく子を産み育て子孫を残すなどの幸福追求権、自己決定権を侵害すると述べています。
Other courts have said that the violation of Article 13 of the Constitution can be found, which stipulates respect for individuals and violation of the rights to pursue happiness, such as bearing and raising children and leaving offspring, and the right to self-determination based on such article.
さらに不合理な差別的取り扱いとして法の下の平等、憲法14条1項に違反するとも述べています。
Some courts have also said that there is a violation of equality under the law, which is stipulated under Article 14, Paragraph 1 of the Constitution as unreasonable discriminatory treatment.
夫婦原告の事件については、憲法24条2項にも違反すると述べております。
For cases in which plaintiffs are married couple, violation of Article 14, Paragraph 2 is also claimed.
3番目として、国家賠償訴訟の経過と現状でございます。全国訴訟提起の経過と現状でございます。隣にいる飯塚純子さんが1997年から有誠実被害を訴えましたが、国は当時は合法と繰り返しておりました。
Next, I'd like to talk about the background and current status of lawsuits for state compensation. First, background and current status of nationwide lawsuit. Junko Iizuka, which is her pseudonym, again, who's sitting next to me, has been complaining about the eugenic surgery since 1997, but the government repeatedly claimed that it was legal at that time.
2015年、飯塚さんが日本弁護士連合会に人権救済の申し立てを行い、2017年、日弁連が人権侵害であるとする意見書を採択し、その報道を見た佐藤由美さん、加盟でございますけれども、その方の義理のお姉さんが支援を申し出ました。
In 2015, Ms. Iizuka filed a petition for human rights relief with the Japan Federation of Bar Associations, JFBA. In 2017, the JFBA adopted an opinion that it was a violation of human rights. The sister-in-law of Ms. Yumi Sato, also a pseudonym, who heard the news, stepped forward and offered to help.
2018年の1月、最初の原告、佐藤由美さんが仙台地裁に訴訟提起をします。そして同年5月、飯塚さん、東京の北三郎さん、加盟でございます。札幌の小島さんらが提訴し、その後、全国12地裁で38人、うち夫婦原告は7組、14名ですが、提訴しております。
In January 2018, the first plaintiff, Yumi Sato, filed a lawsuit with the Sendai District Court. In May of the same year, Ms. Iizuka, Ms. Saburo Kita, also a pseudonym, from Tokyo, Mr. Kojima from Sapporo filed a lawsuit, and other 38 plaintiffs, of which 14 are married couple plaintiffs in 12 regions across Japan followed.
しかし、最初の判決となりました仙台地裁判決を含め7地裁で除籍期間を理由に敗訴が続きました。
However, the first 7 rulings by district courts, including the Sendai District Court, which was the first to rule the case, rejected plaintiff's complaint by applying the statute of limitations, the exclusion period.
2022年、大阪、東京高裁で逆転勝利をします。本年3月までで札幌高裁と大阪高裁で逆転勝訴、3地裁で原告を勝訴しましたが、6月、仙台高裁で敗訴判決が出ております。
In 2022, the High Courts of Osaka and Tokyo overruled the lower court's judgments and awarded damages. By March of this year, Sapporo High Court and the Osaka High Court, which was first filed with Kobe District Court as the court of first instance, and 3 district courts came to decisions in favor of the plaintiff. However, on in June, on June 1st, Sendai High Court have ruled the case in favor of the government.
訴訟における主な争点は、除斥期間、時の経過による権利の執行の問題です。
The main issue of the lawsuit is an exclusion period, which is that by passing of 20 years, the right for the plaintiffs to file a lawsuit expires.
日本の民法724条公団では、不法行為があった時から20年経過をすると、損害賠償請求権が消滅するによる権利消滅を認めるか否かが最大の争点でございます。
The biggest point of dispute was whether or not the right to seek damages have expired by an application of the second paragraph of Article 724 of the Civil Code of Japan, which states that the right to claim damages shall expire after 20 years from the time when an illegal act was committed.
被害者らは20年の間に訴訟提起することは極めて困難であると主張しております。1996年の旧優生保護法改正時点で、約2万5000人の被害者の 98% が手術から20年が経過しておりました。法律が適法だとされている間に、権利侵害を訴えることは不可能であります。さらに、優生政策により助長された差別、偏見により、権利行使が困難でございました。
The victims argued that it was extremely difficult to file lawsuits within 20 years. By 1996, when the former eugenics protection law was amended, for 98% of approximately 25,000 victims, 20 years have already passed from the date of their surgeries. It was impossible to sue for infringement while the law was considered legal. Difficulty in exercising rights due to discrimination and prejudice aggravated by eugenics policies should also be mentioned as well.
被害者勝訴判決は、権利消滅を認めることが著しく正義公平の理念に反する場合には、除斥期間の効果を制限できるとするものでございます。
Judgments in favor of the victims ruled that the application of the exclusion period may be limited if the expiration of rights goes significantly against the principles of justice and fairness.
勝訴判決はいずれも優生保護による強制不妊手術の非人道性、明白な違憲性と、これを放置した国の責任の重大性を理由に挙げております。
All such rulings in favor of the victims cited the inhumanity and obvious unconstitutionality of forced sterilization under the eugenics protection law and the seriousness of the government's responsibility for neglecting it.
優生政策による差別偏見を正当化、固定化助長したこと、平成8年法改正後も適法であると表明し続けた点でございます。
The government's responsibility being, one, eugenic policies justified, solidified, and aggravated discrimination and prejudice. Two, even after the amendment of the law in 1996, the government continued to declare that it was legal, etc.
これに対し、仙台高裁は、佐藤さん、飯塚さんの請求を除斥期間を理由に退けました。
On the other hand, the Sendai High Court dismissed the claim of Ms. Sato and Ms. Iizuka by applying the exclusion period.
飯塚さんが子供を産めなくする手術を受けたことを両親の会話から知った佐藤さんの母が手術を受けたことを認識していたというだけで、2人が優生手術を受けたことを認識したまたは認識し得たと認定し、手術から20年経過する前に訴訟を提起することが およそ不可能ではなかったとするものでございます。飯塚さんについては、それに加えて、1997年から被害を訴え、日弁連に人権救済の申し立てをしたことなどから、平成8年以降に権利行使ができたんだとするものでございまして、被害救済を拒否するに等しい厳しい判決でございました。
On the other hand, the Sendai High Court dismissed the claim of Ms. Sato and Ms. Iizuka applying the exclusion period with mere fact that Ms. Iizuka learned from her parents' conversation that she had undergone an operation which made her unable to have children, and that Ms. Sato's mother was aware that Ms. Sato had undergone an operation. The court determined that the victims came to recognize or could have recognized that they had undergone the surgery, and therefore it was not almost impossible to file a lawsuit before the passing of 20 years since the surgery. And for Ms. Iizuka, the court also stated that she could have exercised her rights in or after 1996, as she complained about the damages since she has complained about the damages since 1997 and filed a petition for human rights relief with the Japan Federation of Bar Associations. The judgment was equivalent to refusal of damage relief.
はい、4番目として一時金支給法についてでございます。国は飯塚さんらの一審判決前の2019年4月の24日、旧優生保護法に基づく優生手術などを受けた者に対する一時金の支給などに関する法律、一時金支給法といいますけれども、制定しましたが、支給額は320万でございます。他方、請求を任用した判決では、慰謝料として1500万円、配偶者も一緒に請求しているケースでは、本人1300万円、配偶者200万円が認められております。
Now I would like to talk about the Lump Sum Payment Act. On April 24, 2019, before the decision by the Court of First Instance on the case of Ms. Iizuka and others, the government enacted the law concerning the payment of lump sum money to persons who underwent eugenic surgery based on the former Eugenics Protection Law, hereinafter Lump Sum Payment Act. However, the amount of payment is 3.2 million yen. On the other hand, in the judgments in favor of the plaintiffs, 15 million yen in case the victims, 15 million yen for the individual victims, and 13 million yen for the victim, and 2 million yen for the spouse, if the spouse is also seeking damages, was awarded as compensation.
はい、そして今求められていることについて簡単にご説明します。4つの高裁の勝訴判決を見れば、除斥期間を認めるべきでないことの使用判断の方向性は明らかと考えております。仙台高裁判決によって高裁判断が4対1に分かれ、最高裁の判断を求めるには時間がかかります。被害者は高齢化しており、すでに38名のうち5名が亡くなっております。命ある間の解決を求めていることから、国に対し最高裁の司法判断を待たず、全被害者について全面解決するよう、弁護団としては求めているところでございます。その一環として、今日このような形で記者会見をさせていただいております。ご清聴ありがとうございます。
I'd like to.
Go ahead. お願いします。お願いします。
Lastly, I'd like to mention what is needed now. Looking at the full High Court's ruling in favor of the plaintiffs, it seemed to be clear that the judicial decision have been directed to disapprove the application of the exclusion period, but the Sendai High Court ruling divided the High Court rulings 4-1. It will take time to seek a Supreme Court decision. As the victims are aging, 5 out of 38 have already passed away. In a hope to come to a resolution while they they still have lives, they urged the government to make a full resolution to all the victims without waiting for the Supreme Court's judicial ruling. Thank you very much for listening.
Thank you very much, Mr. Tokuda. So let's go to Ms. Junko, Iizuka. Iizuka さん、じゃあよろしくお願いします。
よろしくお願いいたします。いいですか。ちょっと見づらくて。すみません。はい。私は宮城県の飯塚純子です。私は16歳の時に何も説明されないまま優生手術を受けさせられました。
My name is Junko Iizuka from Miyagi Prefecture. When I was 16, I was forced to undergo a eugenic surgery without any explanation.
私は本当は障害などなかったのに、知的障害児の施設である小松島学園に入所させられ、学園卒業後、住み込みのお手伝いとして職親に預けられました。
Even though I had no disabilities, I was sent to Komatsu Shima Gakuen, a facility for children with intellectual disabilities. After graduating from the facility, I was sent to my work parent to work as a live-in worker.
職親からは日常的に差別や虐待を受け、優生手術の時も職親に何も説明されないまま診療所に連れて行かれました。
I was constantly discriminated against and abused by my work parent. And when I underwent this eugenic surgery, they took me to a clinic without any explanation.
優生手術は私から幸せな結婚や子供というささやかな夢をすべて奪いました。
Eugenic surgery deprived me of all my modest dreams of a happy marriage and children.
死んだりしていた夫に子供を産めなくする手術をされたことを打ち明けた途端、夫は私の元を去っていきました。周囲は私だけを非難し、離婚を迫りました。精神的な病気になり、働けなくなりました。精神的なストレスが積み重なり、PTSD になっているとの診断が出ています。
As soon as I told my husband, whom I trusted, that I had undergone a surgery that made me unable to have children, he left me. People around me blamed me alone and demanded a divorce. I became mentally ill, which made me unable to work. I have been diagnosed with PTSD caused by accumulated mental stress.
優生手術によって私の人生は狂わさせてしまったのです。
Eugenic surgery turned my life upside down.
私は1997年に優生手術に対する謝罪を求める会に出会い、その後20年以上も被害を訴えてきました。
In 1997, I came across the Society for Seeking Apology for Eugenic Surgery, and since then, for more than 20 years, I have complained about the damages.
この被害が闇に葬られるようなことがあってはならないと必死に訴え続けました。しかし国は当時は合法、謝罪も保証もしないと繰り返しました。
I have continued to appeal desperately with the belief that this harm should never be shrouded in darkness. However, the state only repeated that it was lawful at the time, and thus there will be no apology or compensation.
私は手術の証拠がないことでも苦しめられました。宮城県が規則に反して私の記録を破棄していたのです。
I was also tormented by the lack of evidence of the surgery. Miyagi Prefecture had discarded my records against the regulations.
証拠がないため、訴訟をすることもできず、日弁連に人権救済の申し立てをしました。2017年に日弁連の意見書が出されたことで、ようやく仙台の第一次提訴原告の佐藤さんが名乗りを上げてくれ、宮城県知事が私を被害者と認めたことから、私も2018年5月に提訴しました。
I was unable to file a lawsuit because there was no evidence. So I filed a petition for human rights relief with the Japan Federation of Bar Associations. In 2017, when the Japan Federation of Bar Associations issued an opinion statement, Ms. Sato, who was the first plaintiff in Sendai, finally stepped forward. And the governor of Miyagi Prefecture recognized me as a victim. I also filed a lawsuit in May 2018.
全国で被害者が提訴しましたが、敗訴判決が続きました。20年の除斥期間が理由です。
Victims filed lawsuits across the country, but courts initially rejected the victims' claims one after another. This is because of the 20-year exclusion period.
2022年、ようやく被害者の請求を認める判決が出て、7つの訴訟判決が続きました。
In 2022, a judgment was finally made in favor of the victims, followed by 7 favorable judgments for the victims.
しかし、今年6月1日の私と佐藤さんの仙台高裁判決はまた敗訴でした。仙台高裁判決はすみません。高裁はごめんなさい。仙台高裁判決は訴訟などできなかった被害者の事情を全く考えていないひどい判決です。
However, the decision of the Sendai High Court on June 1st of this year was again to reject the claims of Ms. Sato and me. The Sendai High Court ruling was a terrible ruling in a sense that it did not take into consideration the circumstances of the victims who were unable to sue.
私たち被害者はみんな高齢化し、亡くなってしまう方も出ています。私も体調が悪く病院に通っています。
All of us victims are getting old and some of us are passing away. I'm sick and I often go to a hospital.
この被害を闇に葬らせてはなりません。国の責任は明らかなのですから、国に対し早期全面的な解決をするよう求めます。
We must not allow this damage to be buried in darkness. The responsibility of the government is clear, so I urge the government to come up with an early and comprehensive resolution.
一刻も早い判決ができるよう皆様のお力添えをお願いいたします。本日はありがとうございました。
We ask for your cooperation so that we can resolve this matter as soon as possible. Thank you.
Thank you very much. Iizukaさんどうもありがとうございます。
ありがとうございました。
Okay, for the time's sake, we're going to open the floor for Q&A. And just for your information, the Mr. Tokuda, who sits next to me, he also represented the leprosy plaintiff's trial. So he has experience in a similar case. So if you have any questions, please raise your hand and come forward, cite your affiliation and name, and let's just make one question each. Any questions? Okay, well, okay, go ahead. じゃあ、カリンさんどうぞ。
今日の記者会見ありがとうございます。ラジオフランス、リベラション新聞の特派員西村と申します。2点お願いします。飯塚様、すいません、質問させていただきます。1970年代に、手術を受けたと思うんですけれども、はい、1997年に訴えることになりましたが、その20年間以上の間にどういった生活だったか、ちょっと説明いただけますか。
手術を受けたのは16歳の時に。
16歳の時、1970年代ですよね。はい、ですよね。はい。はい。もう一点は、飯塚さん様は、宮城県の知事に、被害者として認められたということですが、それに基づいて国の一時金の請求とかはできましたか。
しました。
Let's translate the question first. すいません。まずちょっと要約で結構です。質問をちょっと英語にしてください。はい。
So my question is that Ms. Iizuka had a surgery in 1970s, and she filed a lawsuit in 1997, but filed a petition in 1997 with the JFBA. But during that time, what was your life like? And also, when the Miyagi Prefecture, the governor of Miyagi Prefecture, admitted that Ms. Iizuka is in fact a victim of the eugenic surgery, did you apply for the 3.2 million compensation?
まず優生手術された後のことですね。手術された後は一応父親が実家に連れて帰って、その後父親と母親が子供を産めなくされたっていう話を聞いて、それから悩みが始まりました。ただ優生保護っていう言葉は聞いたことがなかったんで、その後しばらくしてから東京品川の江原に就職しました。ただ体が調子悪くなったんで、手術によって後遺症があったり、それで仕事も長く続かない状態でした。あとは何でしたかしら。もう一点が宮城県の知事が飯塚さんを被害者だと認めた後に。
Yeah, while interpreter explains the question, let me just get the record straight. She's 77 years old. She received the surgery at the age of 16, so it's 61 years ago. So it's 1961 or 62 when she received, isn't it? 61 years ago. Yeah, she's 77 and then she received at the age of 16. So it's 61 years ago. So it was early 1960s when she received the procedure. Okay, go ahead. お願いします。
宮城県知事。宮城県知事が認める前に、私優生保護手術台帳の申請をしましたが、書類は焼却されてないために、佐藤さんよりも本当だったら先に裁判が進むべきであったんですが、佐藤さんが書類があったんで先に進んで、私は書類がないために 村井知事がたまたま定例記者会見をしたんだそうです。そこで話したことをマスコミの方からうちの方に何度かお電話をいただきまして、それで裁判するようになりました。書類がなくても認めるっていうことで、北海道と仙台は私、東京は北さんの裁判が同じ日に提訴っていうんですかね、しました。320万円は受け取りました。
Thank you for your question. So, with regard to my life after the surgery, I was taken back to my home with my father and my mother, and I was told about the surgery from my mother. But I
ごめんなさい、どうぞ続けてください。
But I have never heard about eugenics or what it means, and I started working in Shinagawa area, but I also had an after effect of the surgery which prevented me from working for a long time. And as to the lump sum payment, I did file an application and I have received the lump sum payment.
Okay. Let me just have a brief explanation. I straightened the record in English about the date of her surgery. She's 77 years. でそれを日本語にinterpreter didn't translate it, so let me just make the translation in Japanese. 彼女は今77歳で16歳で手術を受けているので、61年前なので、手術を受けたのは実際は1960年代の前半、61年か62年あたりになると思いますけど、そういうなのでちょっとそこだけ先ほど英語で言いましたけど、通訳の方お話しててできてなかったので、それだけ、一応記録を修正しておきます。Okay, next question. Okay, go ahead, please.
こんにちは。Keiko Kurane, I'm a freelance journalist. My question for Ms. Junko Iizuka, have you tried or have you been able to find ways to heal from the trauma caused by the Eugenic law? And what message would you like to convey to the public who may be unaware of its impact in Japan? Thank you.
飯塚さんへ、質問させていただきます。飯塚さんが手術によって受けられたトラウマからですね、回復されたかどうか、そういう機会があったかどうかということを教えていただきたいということと、この問題について、まだ知らない方たちがたくさんいると思うので、その方たちに向けて何か伝えたいことがありましたらお願いいたします。
はい、すいません、頭が混乱してて、すぐもう。
一つずつ、はい、最初の質問は、飯塚さんが手術の後 PTSD になられたという話が先ほどありましたけれども、そこから回復する機会があったかどうか、回復することができたかどうか。はい、お願いします。
回復してません。
No,
あります。
No, I'm still suffering the trauma. I've never recovered from the surgery, the trauma caused by the surgery. 次の質問は、皆さんこの問題について、まだ知らない方に対して何か伝えたいことがあれば。はい、
皆さんにぜひ名乗り出ていただいて、国からきちんとした責任を取って謝ってもらいたいし、責任を取っていただきたいと思います。
So I would like to encourage the victims who have not yet come forward to file or apply for the lump sum payment. I would like to urge them to come forward and apply for the lump sum payment, and also to claim the damages and to join us in making sure that in pressuring the government to make sure that they have they take the measures to relieve the suffering of the victims.
Okay. All right. Let me take the liberty of asking a question from the front desk. 最初の英語で言います。新里先生と徳田先生にぜひお伺いしたいんですが、We have two distinguished lawyers today, so I have a question to them. What's the logic behind governments fighting again, in these cases? I understand that the government has already acknowledged the wrongdoing, and it's so obvious that something wrong was done in the past. But I think many people would be surprised to hear that they are fighting in a court battle against the victims. And since you two have experience of fighting in similar cases as well, why does government fight to up to the Supreme Court? Because it takes time. As you said, five plaintiffs has already died, and time is running out. But government fights to the end. What's the logic? Why are they fighting? If you can speak from your experience in other cases as well about the logic of the government. 今日本語で言いますと、結局先生方は他にもハンセン病とかいろんなケースで政府と対峙されてきているわけですけれども、もう政府はこの非を認めているにもかかわらず、なぜこの損害賠償に関してはそんな最高裁までね、相手がどんどん死んでるって言って時間の問題もあることが分かっているのに最高裁まで戦う、どういう論理で政府というのはそのようなことを主張しているのかをぜひお話しいただければと思います。両方でも結構ですよ。はい、
それじゃあ私徳田の方からお話したいと思います。日本政府が取っている論理は古い話だ。要するに古い昔の話だから自分たちには責任がないという論理ですね。でこれは日本政府、それから日本社会が差別の問題についてダブルスタンダード、つまりナチスドイツの T4 アクション等に関しては声を大にして批判する。しかし自分たちの国が犯してしまった T4 アクションに匹敵するような人権侵害に関しては古い話だという形で責任を逃れようとする。ハンセン病問題等に関しては、いわば国民の厳しい批判を浴びる形で解決をしたけれど、この優生保護法問題に関して言うと、自分たちが犯した罪であるにもかかわらず、古い話だという論理で責任逃れをしようとしていると。だからダブルスタンダードだと思うんですね。私はそこにこの問題の一番の根源があると思っています。
それでお願いします。
So, put it in a simple word, it's the government's argument is that it's an old issue. The government is taking the double standards in a sense that it has criticized severely what has done by Nazi, but in this case, they just try to avoid their responsibility by saying that it's an outdated old issue.
Okay, 次新里先生よろしいですか。
はい、じゃあ、
はい、
徳田弁護士が言ったのが真意で、内部的にはいわゆる法務省が非常にこの抵抗している、いわゆる全体解決に対して抵抗しているとか実際あります。で、何かというと、このいわゆる20年の除斥期間というのが国の責任をですね免除するような大きな作用をしてきた。例えば戦争中の日本軍人の加害行為についてこの除斥期間で救ってきている、そういう除斥期間のルールを守りたいという背景が法務省の中にあるのではないか。被害を見ないでですね。ただ今日本で民法が変わってですね、除斥期間がなくなってしまっているんです。全部が時効になっているんです。例えば一定の事情があれば中断をするよねとかっていう柔軟に解決できるような仕組みになっている。だけれども この事件については除籍っていうのが適用になるもんで、非常に硬直的な判断をして被害者を見ていないのではないかなというふうに思います。
So what Mr. Tokuda said is the actual the intention behind the government, but there's another reality is that Ministry of Justice also fighting against this. The background of that being that they have in the previous court rulings, they have exempted the government's responsibility by applying this statute of limitations or exclusion period for their responsibilities under the World War for the illegal conducts done during World War. And so their intention, I suspect, is to protect or keep this ground in order for them to be able to protect the government. However, the exclusion period, as I mentioned earlier, has already been removed from the current civil code. It was amended in 2020. And so it's no longer there. Everything related to the statute of limitations under the current civil code has some sort of exceptions that could be applied in case-by-case scenario.
So you're saying that if they don't claim the statute of limitation, in this case, it could affect other cases or future other potential cases. 要するにここで除籍期間を認めないようなことをすれば、他のそうした責任問題にも影響することを懸念しているということですか。そうすると。
そうだと思います。逆にだからこそこの被害というのは特殊だ。戦後の違憲な法律被害だっていうことであれば、その事案としての解決ができる。他に影響を与えないで、だからこそ政治解決が必要だと私は思います。それからそのために被害者が声を上げる、今日のようにですね、それをメディアの皆さんがどう支えていただけるかが政治を変える大きな力になるのではないか、そんな思いで今日ここに来ています。はい。
I think so. It is true that the government is worried about the influences that this court decision will have in future similar cases or cases in where there is a violation of human rights. And therefore, I believe that the political resolution is vital to this case. With the political resolution, there will not be any concern of the government to have any influence or influence in other future cases. And I also believe that the power of media is vital in supporting us to change the government's attitude.
Okay. Thank you very much. Time is running out, but just one quick question or the confirmation just came via email. There was a report yesterday that one 9-year-old boy and one 9-year-old girl did receive the sterilization surgery. What are your views? 昨日たまたま、ニュースで9歳の、男の子女の子までが、不妊、手術を受けていたっていうのがニュースになって、ちょっとそれを見た外国のThe question was actually came from 京子長谷川 the AFP 外国の報道機関からちょっと質問できてるんですけど、それ驚いたんだと思うんですが、これはもともとはもう9歳がいるってことは分かってたことですよね。ちょっとその被害者のそのスケールといいますか、年齢層とか、人数は先ほど25,000人っていう話が出ましたけど、年齢層とかちょっとなんかそういう事実関係の部分で、少し簡単に説明、短くて結構なので説明いただきますか。I asked them that in response to this question about the 9-year-old boy and girl, actually there was a prior knowledge that the 9 years old boy and girl had actually received the surgery. We've known that from before, but I just asked them to give a brief sort of outlook of what the actual surgery it was like, what the age group and what type of surgery was done. Just a quick brief on that. じゃあ、先生どちらでも結構ですので、もうちょっとどんな、あれだったのかっていうことですね。
19日に公表されましたその報告書の一部ですけれども、1400ページというタイムなものですけれども、基本的にはこれまで調査した結果をまとめたというところが大きくて、今9歳の方の話は出ましたけれども、もうすでにマスコミでは報道されて、以前相当前から報道されていたことでございます。ただ女性の方が非常に多かったということや、それから少ないのですけれども、40人のうち6割以上の方が全く知らされていなかったというようなことが出ています。そういう意味では私たちは提訴した時点で非常にひどい被害だということが調査の中でも確認された。だけども一つはなんでこんなひどい法律ができて48年続き、そして法改正したのになんで責任を取らなかったという総括の部分がないというのが極めて残念で、それが今後求められているところではないかなというふうには思います。
So the report that was handed over to by the Diet revealed that the facts that we have known even before the report was made public, but as mentioned earlier, the report consists of 1,400 pages, and there were facts such as that the youngest victims are aged 9, boy and a girl, and also the fact that the vast majority of victims were women, and the facts such as that over 60% of the victims were not made aware that they were in fact undergone the eugenic surgery. But the issue with the report is that they did not mention anything about why the law was created, the intention behind, and why there was no compensation for such a long period of time.
Okay, thank you very much. どうもありがとうございます。飯塚さんも本当にどうもありがとうございました。Okay, thank you very much for coming for the press conference. I'm going to just wrap up this press event today, and thank you for coming for the press conference.